Hello students, in today we will be tracing the fascinating journey of labor legislation in India. To make it simple, we can divide this history into three broad phases. The phase before the International Labour Organization, at that time laws that were mostly oppressive. The phase after the ILO but before independence, at that time laws became more regulatory. The phase after independence, in this time laws were shaped by the Constitution of India, mainly welfare-oriented. Let's first go back to the 19th century. At that time, Indian labour laws were heavily influenced by the interests of British employers and their economy. Laws were not made for the welfare of Indian workers, rather, they served the needs of colonial industries. For example, the Bengal Regulation of 1819 made refusal to work by a contractual worker a punishable offence. Imagine that, a worker could be punished simply for saying, "I don't want to work under unfair conditions." In 1843, the Indian Slave Act was passed, which on paper outlawed slavery. But in practice, bonded labor and agricultural slavery still continued in many forms. Then came the Apprentices Act of 1850, which was not for general skill development but meant to provide vocational training to juvenile convicts aged 10 to 18 years. The Breach of Workmen's Contract Act, 1859, is another shocking example. If a worker broke his contract, he could be punished, even jailed. But if the employer exploited him, there was no penalty. Clearly one-sided. Some laws like the Factories Act of 1881 and 1891 did bring minor protective measures like banning work of children under 7 years and limiting working hours for women, but these were too little and mainly to keep workers just fit enough to work. And of course, we can't forget the Assam Labour Emigration Act of 1901, which pushed poor peasants into tea plantations under exploitative conditions, almost like legalized slavery. So, this phase was mostly about oppression and control rather than welfare. Now students, let's fast forward to the early 20th century. Something very important happened in 1919, the establishment of the International Labour Organization, ILO. India was one of its founding members. This brought global pressure to improve labor conditions. The Government of India Act, 1919 gave the centre more powers to legislate on labor issues, and by 1935, labor matters were divided into the federal list, concurrent list, and provincial list. During this period, several commissions played a big role. For example, the Royal Labour Commission of 1929 led to the Factories and the Payment of Wages Act of 1936. The Adarkar Committee of 1943 eventually led to the Employees State Insurance Act of 1948. Some landmark legislations of this phase were Employees Compensation Act, 1923 Compensation for Accidents. Trade Unions Act, 1926 gave recognition and rights to trade unions. Payment of Wages Act, 1936 ensured timely payment without unauthorized deductions. Industrial Employment, Standing Orders, Act, 1946 standardized service conditions in factories. These laws were more regulatory, they tried to create balance between employers and workers, though they were still far from true welfare. Finally, after 1947, labor laws took a completely new turn. Why? Because the Constitution of India itself became the guiding force. The preamble talks about justice, social, economic, and political. The fundamental rights, Articles 14, 16, 19, 23, 24, guaranteed equality and protection from forced labor and child labor. The directive principles of state policy, Articles 38, 39, 41, 42, 43, 47, clearly ask the state to ensure humane working conditions, fair wages, and social security. In this spirit, several landmark welfare laws were enacted. Factories Act, 1948 covering health, safety, and working hours. Mines Act, 1952 similar provisions for mine workers. Minimum Wages Act, 1948 ensuring fair wages for unorganized workers. Employees Provident Fund Act, 1952 retirement security. Maternity Benefit Act, 1961 protecting women workers. Bonded Labor System, Abolition, Act, 1976 ending bonded labor. Child and Adolescent Labor Act, 1986 prohibiting hazardous child labor. And more recently, the Unorganized Workers Social Security Act, 2008 extending protection to informal sector workers. These laws were influenced not only by domestic needs but also by ILO standards. For example, India ratified conventions on child labor, leading to stricter child labor prohibitions. Over time, Supreme Court judgments also expanded labor rights. In Bandhua Mukti Morcha vs Union of India, the court broadened the definition of bonded labor to ensure greater protection. Today, labor reforms are also being aligned with globalization and the ease of doing business, leading to codification of multiple laws into labor codes. So students, to summarize, the first phase before ILO was mostly oppressive, meant to serve colonial employers. The second phase, after ILO but before independence, brought in regulatory laws influenced by global standards and commissions. The third phase, after independence, gave us welfare-oriented labor laws guided by the Constitution, international commitments, and social justice. This historical journey shows us how labor law in India evolved from exploitation to protection, and from regulation to welfare. Dear viewer, if you found this video useful, we kindly request you to subscribe to our channel. Your likes, comments, and shares truly encourage us to create more such content. For free PDF notes and free multiple choice question practice on this topic, please visit our website. The link is provided in the description box. Thank you so much for watching and supporting us.